Our guest today is a justice of the Illinois Supreme Court. As Skinny mentioned, 47 years ago, next week, July 20th, 1968, she changed the world forever with children and adults with special needs. Just after marrying her sweetheart, legendary public servant Ed Burke, she was a young instructor from the Chicago Park District, and she organized an athletic competition in Soldier Field. She teamed up with Eunice Kennedy Shriver, and they called it the Special Olympics. The world was changed forever, and the Special Olympics is now celebrated, as Skinny said, in nearly 200 countries around the world. Our guest today and her husband, Chairman Ed Burke, are the proud parents of 5 fabulous children, one who is here. Sarah, where are you? Sarah, stand up. This is Sarah Burke, great City Club member, great friend of ours. Thank you, Sarah. And grandparents to 9 extra fabulous grandchildren. Ladies and gentlemen, Supreme Court Justice Ann Burke. Madam Justice.
Thank you all very much. So good afternoon, everyone. And again, thank you, Jay, for that very kind introduction. But people do add up those numbers, and unfortunately, they're going to be figuring out how old I actually am. But I do want to thank Jay and the City Club Board for inviting me to speak with all of you today. The last time I addressed the City Club was in March of 2004. My topic was the report of the Lay Review Board of the United States Conference of Catholic Bishops investigating the clergy sexual abuse crisis in the United States. Well, I just want you to know today's invitation is not that controversial. Jay suggested that I share some stories about the history of the Illinois Supreme Court. So I've gathered a few stories. Whether they're interesting or not, well, I'll let all of you be the judge of that. Until I came onto the Supreme Court 9 years ago this month, I never really thought much about the court's history. But becoming a member of an institution that began in 1918 changed all of that. Perhaps it was the pomp and the protocol to which the court continues to honor that caused me to become fascinated by my fellow brethren, even going back for 2 centuries. I have learned that the Illinois Supreme Court has undergone many changes before becoming the court it is today. Surprisingly, under our first Constitution, the Supreme Court was comprised of only 4 justices, who were not elected, but rather appointed by the General Assembly. They must have been rough and hardy individuals because the General Assembly required the justices to ride the circuit, which meant they had to travel the 4 judicial districts where they were to convene court. And I suppose saddle sores were an ordinary part of that judicial life back then. But of course, it was really the perfect storm, I think. The justices could confirm their own opinions. It's ideal, isn't it? Under the first Constitution, the General Assembly held enormous power over the judiciary. The state's entire judicial structure was subject to the whim of the legislature. Because of that, it was altered frequently, often as a result of a change in the partisan makeup of the legislature. This caused the entire court system to be in constant upheaval. That first court met in Kaskaskia in 1818. Later, the General Assembly increased the court to 9 members. In addition to the circuit courts and circuit court judgeships that came into and out of existence at the complete discretion of the legislature. It was very difficult to have confidence in such a chaotic and haphazard court system. The need for an independent judiciary became obvious. By the way, there's a side story about how the Supreme Court came to be increased to 9 members. As the story goes, Stephen A. Douglas, who was Secretary of State in 1840, used his position to lobby for the passage of an act increasing the Supreme Court to 9 members. The motivation behind his support of this act was his involvement in a politically charged case, People ex rel. McClelland versus Field. The Supreme Court, the majority of whom were Whigs, ruled favorably for the Whig defendant Alexander Field over the Democrat John McClelland, who was represented by guess who? Douglas. And in the aftermath of this loss, Douglas became determined to bring about a change in the political leanings of the court. And it should come as no surprise that in 1841, when the law was finally passed, Douglas had himself appointed as one of the new justices. He was just 28 years old, making him one of the youngest justices ever to occupy the Supreme Court bench. He remained a justice for only 2 years, moving on then to other endeavors. By the way, I am not telling you how old I was when I first went on the bench. In 1848, largely because of the problems created by the legislatively controlled judiciary, a new Illinois Constitution was adopted. It completely restructured the court system, establishing a Supreme Court composed of just 3 justices. However, they were elected by popular vote. Now, nationwide, there are 340 state Supreme Court seats. 25 states select their Supreme Court justices using the Missouri Plan, which is a merit selection system whereby a nominating committee approves several candidates and one is ultimately appointed by the state's governor. 12 of those 25 states also require Senate or House confirmation of the governor's selection. And only 2 of the states use a hybrid merit selection where the governor has sole discretion to appoint. But the appointment is then subject to the confirmation of a commission on the judicial appointments. Now, 9 states elect justices by partisan elections, of which Illinois is one, while 13 states elect justices with nonpartisan election, and the remaining 2 select Supreme Court justices by legislative vote. And I'm sure Representative Feigenholz would prefer that. Under the 3rd Constitution of 1870, fundamental changes occurred in the operation of the court. Many of them remain today. For example, the Supreme Court was increased to 7 justices, the same number we have today. The Supreme Court was given authority to make rules to regulate the judiciary statewide, which now included an appellate court. And finally, the Supreme Court was required to hold court 5 times a year in Springfield. This is how the court still operates. The 5 sessions are held in January, March, May, September, and November. And these times are called terms. When the court was increased to 7 members, the Supreme Court courthouse became rather crowded. So a new building was needed. But in the interim, the court moved into the venerable old Capitol building and waited until the new state Capitol building was completed in 1877. Then on February 4th, 1908, the court moved to its present location on the corner of 2nd and Capitol Streets in Springfield, kitty corner to the state Capitol. And by the way, there is a tunnel running from the state Capitol underground to the Supreme Court. But I want you to know there is an iron gate with a lock on it. We put it on. But I've also heard some rumors, an unofficial story about how the new court building came to be. The story involves a card game, a lot of whiskey, the justices of the court, an Illinois governor, Charles Deneen, and a wager. Now, I've never been able to get all the details, but just let's say that the members of the court had luck on their side late one evening. But there's also something else you might not know about the Supreme Court building. When the court convenes in Springfield 5 times each year for a term, the members of the court, in addition to working in the Supreme Court building, we also reside there. This has been the practice since the new courthouse was constructed. So in August 2006, in anticipation of my first term in September, I traveled to Springfield to visit the Supreme Court building and bring a few personal items. When I arrived, I immediately visited the 3rd floor, where the justices reside, and began to search for my assigned room, the Cartwright Suite. So named because James H. Cartwright, who served on the court from 1895 to 1924, was the first justice to occupy that room. Now, as Chicagoans, you might be interested to know that it was Cartwright who authored the decision in 1902 entitled Bliss v. Ward, the case which he affirmed that Chicago's lakefront must be kept forever open, clear, and free. Now, this case began when Montgomery Ward filed suit against the city's Board of Commissioners of Lakefront Armory and Parade Grounds to enjoin them from building any structures in Lake Park, which is now Grant Park. Mr. Ward won in the lower courts, but the city and the Illinois National Guard attempted to bypass the court's ruling by claiming that newly filled-in lakefront areas were exempt from the decision because they were underwater and therefore not part of Lake Park when the court ruled. Fortunately for Ward, Cartwright did not interpret the law that way. His decision saved Chicago's downtown lakefront. Does this sound familiar? Cartwright is in this photo, as well as Floyd Thompson, who was the Chief Justice at the time. Thompson is in the very center, and to his right is Cartwright. I should say, his right, your left, is Cartwright. I might add that a few years after this picture was taken, Chief Justice Thompson left the court to run for governor on the Democratic ticket, and he was unsuccessful, losing to a Republican, Lewis Lincoln Emerson. Thompson then went on to become a founding partner of a Chicago law firm known today as Jenner and Block. And there, in 1955, he hired a young attorney some of you may have known, Gerald Salovey. Looking back to that August day in 2006, one of the first things I noticed when I entered the 3rd floor was that there were brass plaques on the walls outside of the entrance of each one of the rooms. The plaques listed the names of every justice who had ever resided in that particular suite, along with the dates of their residence. Then I recognized a number of the justices' names that were listed on the plaques, but especially the one on outside of my room. One name, however, Seymour Simon, stood out, and some of you may remember him. Justice Simon served on the Illinois Supreme Court from 1980 to 1988 and was a longtime Burke family friend. As you all know, Justice Simon, well, first of all, he's seated second from your right. Also pictured here is a retired former Chief Justice Benjamin Miller, who served on the Illinois Supreme Court from 1984 until 2001. He's the one with the really dark hair on the end, but he's with us today, and his hair is different. Justice Miller. Also, some other Chicagoans are in the photograph. In the very center is actually Chief Justice William Clark, and to his right, your left, is Justice Daniel Ward. Justice Simon, my father-in-law, and Joseph Burke served together in the Chicago City Council in the early 1960s. In the latter part of the 1960s and into the 1970s, Justice Simon served on the City Council with my husband, Ed. Justice Simon's son, John, was my campaign chairman when I ran for a seat on the Illinois Appellate and Supreme Courts, and now John is on the Appellate Court in the 1st District. So with all of that history, I felt it was quite fortuitous that I should be assigned to Justice Simon's room. So I thought Justice Simon would be pleased as well. Now, at that time, Justice Simon's health was very poor. So I visited him at RIC Hospital and took along a picture of the plaque outside our room. When I told him that I was sleeping in his bedroom, he said, "Say it a little louder so the nurses can hear." But in all honesty, I was very pleased to have been assigned to Justice Simon's former room. I long admired his frankness and legal scholarship and hoped that his spirit might have lingered there and would become an inspiration for me. Justice Simon was known as the lone dissenter. He had a keen legal mind and strong moral convictions. He was undaunted when the other members of the court did not agree with him. He would simply just write a dissent, elaborating on his views. Justice Simon is perhaps best remembered for his powerful dissents regarding the death penalty in Illinois. He voiced his opposition to the death penalty for the first time in 1981 in People v. Lewis, and dissented in every death penalty case which came before the court in the ensuing years. His reasoning was based on the fear that the death sentence could not be equally applied by the 102 counties' state's attorneys. Of course, his views were proven correct. Beginning in 1987, more than 20 death row inmates were exonerated and ultimately led to a moratorium on the enforcement and then the elimination of the death penalty March 9, 2011. And I also want to mention here that there is also a room across the hall from the Cartwright Suite that used to have a red telephone. The purpose of the telephone was for the warden to call on the evening before an execution. And by constitution, an execution could only take place during the court term when the justices were in residence. All would be awake to take the call, and each had to respond to the warden's question: were there any papers pending? If there were, then no execution would take place. Justice Mcmurray, my mentor and friend, often told me she was haunted by the one time she had to participate in that call. Now, with the passing of time, I have come to believe that having resided in the Cartwright Suite, the spirits of Justice Simon and the ghosts of my bedroom, who resided there before me, truly have inspired me to develop my own judicial voice. While on the appellate court, I rarely dissented, and to tell you the truth, it was only once, and my colleagues helped me. However, in the 9 years since I've been on the Supreme Court, in addition to authoring almost 100 majority opinions, I have written 34 dissents or partial dissents and 12 special concurrences. So each time I look at those plaques outside the suites, and I am reminded of the many jurists who have occupied those spaces, each one unique and each with a story of their own. Even the plaques themselves tell a story of the diversity or the lack thereof of the court and its evolution. For example, the plaque outside the Orrin and Carter suite reveals that Marianne Mcmurray, the first woman ever to serve on the Illinois Supreme Court, resided there from 1992, when she was elected to the court, until 2006, when she retired. Never having a desire to move to a different location, she was content to remain in the seat or the suite she was originally assigned. And today we have with us her daughter, Dr. Marianne Mcmurray, who we fondly recall to as Marianne Jr. Marianne? The Cartwright Suite, however, has hosted every other female member of the court. The second woman on the court, Rita Garman, was the first woman to reside there. She is currently our Chief Justice. And when I came onto the court, Justice Garman decided to move to the Carter Suite. That is how the Cartwright Suite became my assigned lodging. Now, I too have moved. I presently reside in the William M. Farmer Suite. And he died only 2 months after moving in. I'm just glad I didn't know that. And by the way, I don't plan on voluntarily retiring anytime soon, nor do I hope to follow in his footsteps. So when I moved into the Farmer Suite, the fourth woman to become a member of the court, Justice Mary Jane Teist, moved into the Cartwright Suite, and she resides there presently. Now, I realize the lives of the Illinois Supreme Court justices appear differently to all of you and to others, and sometimes I really look back in wonder at the path that brought me to the Supreme Court. It is truly a position of honor. But just in case I ever get the thought of getting a swelled head, I have a family to keep me grounded. Thank you, Sarah. I will never forget my first term in September 2006. The court was in session in Springfield when I received a phone call from my husband. It was just before we were about to retire and join my colleagues on the bench for the very first time. I was extremely nervous, and it really was not a good time to take a call. But, as you would do, I thought Ed was probably calling me to wish me luck. I was wrong. When I answered the phone, Ed said, "The buzzer on the new stove has been going off all night, and Travis and I can't get it to stop. What do I do?" So much for the glamour of the state's highest court. I had to call apt. That's what I had to do before I went on the bench. Upon becoming a member of the court, I soon discovered that virtually everything we do is governed by protocol. How we enter and exit the courtroom for oral argument, and our seat assignments on the bench are all determined by seniority. When entering and exiting the courtroom, the Chief Justice proceeds first, while the junior most justice enters and exits last. However, when we deliberate on the cases after hearing oral argument, the opposite is true. Here, the junior most justice speaks first. This practice is based on the theory that the more senior members should not influence the less senior members' thinking. But of course, there are those, like my family, who believe this should not have been a concern in my case. Also on the third floor, in addition to our suites, there is a dining room where we all dine together. Here, too, our seating is assigned to according to seniority. In every respect, the court is governed by the rule of 1 to 7. Even the cases are assigned in strict rotation according to the numbers on the grid. It is true that our living together in the courthouse is rather unique. There is only one other state which follows the same practice, and that is Missouri. And I believe, however, our ability to interact on a more informal basis creates greater collegiality. Perhaps the other branches of Illinois government should try this. Of course, our living together does not mean that we talk shop all the time. And in fact, it is a cardinal rule to which we adhere that no conversation take place about the matters of the court in our off hours. Whether we are in Springfield or in our judicial districts, those discussions are totally reserved for only one place, around a 100-year-old table in the conference room called the Impression Room, located right behind the Supreme Court bench. Now, this photo depicts the justices sitting around the same table back in 1909. The all-male panel looks rather formidable, but I can assure you that the room has hardly changed, with the exceptions of some better lighting, some more comfortable chairs, and the lipstick that Justice Garvin, Justice Tice, and I keep in our drawers. I can only imagine how that would go over with these distinguished jurists. Although the Supreme Court has been a big part of my life for the past 9 years, I recognize that most people, even most lawyers, will never have the opportunity to see the inside of the Supreme Court room or even to witness the oral arguments before the court. Except now you can actually view oral arguments on the Supreme Court's website the same day the arguments are heard. It was this realization that most people will not have the opportunity to be present for oral argument that the court was prompted recently to invite the other branches of government to attend a special evening session of the court. So many legislators, even Governor Rauner, accepted our invitation, and in March of this year, they watched and listened to the oral arguments on a case involving a minor in which the court was asked to interpret certain legislation. The courtroom was packed, and we even had to broadcast via closed-circuit television into another room. The event was extremely successful, and we received much feedback that was extremely positive. Now, during oral argument, we quoted many of the statements made by the legislators when the bill was being debated in an effort to determine the intent of the legislature. They were very surprised at this process. But I may be biased, but I think it's very interesting to know exactly how the judicial branch of government functions in relation to the other branches. Well, I hope I've intrigued all of you so that you will wish to visit our beautiful courthouse in Springfield. So I invite all of you to come to Springfield when the court is in session. Come and listen to oral arguments. You can watch it on the website to get prepared first, and even read the briefs before you come, so you can know what we're talking about. But I think that every citizen in the land of Lincoln should have this opportunity and should witness the Illinois Supreme Court in session. Thank you for your attention.
Well done.
Thank you, Paul.
Justice.
Professor.
If we have, by the way, take out your blue books. We'll be supplying the pens. It'll be a short essay exam. Any elected official is disqualified. All right, are there any Any serious, hard-hitting questions on this? Any negative questions? Seeing none. From Christy Hefter, what do you think of the idea of specific terms for U.S. Supreme Court justices? Staggered? Oh, you mean staggered terms. I gotcha. We don't talk about justices being staggered. We're talking about staggered terms.
Well, Christy, that kind of a question is left up to the legislative process in the federal government at this point in time, just like it is in Illinois. So.
I just wanted your opinion.
Yeah, I know. I know what you wanted, Christy. But I'm actually of the position I cannot answer your question, and I can be affirmed.
Okay.
There are
Well-
certain questions I just can't obviously answer and give opinions to.
Okay. Well, this has nothing to do with what you said, and you may not want to answer this one. This is from Scott Celia. Can you tell us what the Alton School project was and its importance to the court?
Oh, I can't answer this. This is a terribly exciting situation. Back in the middle 1800s in Alton, Illinois, Alton was a safe haven for freed blacks. They assimilated there, became businessmen and women, and participated in life in Alton, Illinois. And at some point, the city council in Alton decided that that should all change. They decided that black children should not go to the Alton schools. And Scott Bibb was the father of Minnie and Ambrose Bibb, and he insisted, filed a lawsuit, and it went all the way up to the Illinois Supreme Court several times, and the Illinois Supreme Court said they're wrong. Children belong in their school district, and it was against the law for the city council in Alton not to permit them to be part of it. Now that brings us to the point which I think Scott really wanted us to say. Scott Zala's here, Neil Cohn's here, and Joy Cunningham's here. They're involved with the Illinois Supreme Court Historic Preservation Commission. One of the commissioners here is Joe Power, and they preside over the Illinois Supreme Court Historic Preservation Commission, looking into the legal cases throughout Illinois, searching for ones that we can use as educational tools to learn about how the law evolved in Illinois. And Alton is the perfect example. We've had a retrial here, and we also have a table of DePaul University, who is the theater people who have put together Dean Corin and Shane, John Colbert, Dean of the Law School, or the Theater School, who have put these 4 trials together over the last 4 years. Mary Surratt, Mary Todd Lincoln's retrial. She was found insane under the 1875 Lunatic Act. Now, my friends from Maddow and Thresholds and all, that's the term that was used in 1875. But we retried her under today's mental health code, and she was not found insane, but she did have mental health issues. And therefore, she didn't need to be incarcerated into an institution, but could stay home and get services. And that's what the Kennedy Forum Illinois is all about. And I think we like to shake everybody should clap for the Kennedy Forum Illinois back there. Peter O'Brien is president of that, and we're trying to erase the stigma on mental illness. And it's with every step we can do this through the law. We also retried Joseph Smith last year, and of course this year that we had the Alton trial. So thanks, Scott, for bringing that up.
Did you find Joseph Smith guilty or not guilty?
He was already dead.
He's already dead, that's right. It's a beautiful prison you could visit in Western Illinois. It's great site. All right, Mara Georges, you talked about cases being assigned by rotation. Are you able to select a case and write an opinion off the grid?
Absolutely not.
Take that. All right, now we have two questions from John Legg and from my man with the boat, Ashton. Do you see any realistic chance, Madam Justice, that key word is realistic, for merit-based selection or election of merit-based selection of justices or judges, or do you have any thoughts on how justices should continue to have lifetime appointments, or should there be limited to 10 to 12 years? If you don't want to answer either one, just say no comment.
No comment.
No comment, as I said. That's why this lady is an important justice in the state of Illinois. Any others? By the way, since this is Maria High School Day, that picture of those justices, one of the pictures with Seymour Simon, my wife's uncle was there, Bill Clark. So it's all in the family. What can you say? Ladies and gentlemen, how about a big round of applause?